You can step on chairs, and you can jump from one chair to another chair. You can step on tables. You can take the cushions off the couch and throw them on the floor and step on those. But if you step on the ground, well, then the ground is lava. You lose that leg or something like that. Of all of the chapters of this book, The Concept of Law, that we're talking about in this course, this chapter is probably the most controversial and the most interesting. We're talking about Chapter 6, which is called The Foundations of a Legal System. You'll remember from last time, or 2 times ago or whatever, we had read Chapter 5, right? After demonstrating that Austin's theory of law doesn't work in chapters 3 and 4, Hart moves on to presenting his own theory. We got the first sort of half of the presentation of his own theory in Chapter 5. That was all the stuff about primary and secondary rules. Remember all that? And now we get a sort of extended discussion about one of those primary rules, the most important one. It's called the rule of recognition. Because you remember, the 3 types of secondary rules that Hart talked about in Chapter 5, those were all introduced to remedy certain defects with systems of rules or proto-legal systems that only had primary rules, right? And so we got these 3 different types of secondary rules. But the rule of recognition, it does more than just remedy the defect of uncertainty. The defect was uncertainty about what the law even is, right? And the rule of recognition is this rule that is supposed to recognize which laws count as law, which laws have what we call legal validity. They're legitimate laws of the legal system. This rule remedies this defect, but it also does something else. It explains how legal systems are unified. It explains how all of these different rules are not just, separate social rules created by human beings floating out there independently of one another, but rather they are, in some sense, collected together into a legal system, right? This is just a fact, a manifest sort of, undeniable fact that, one rule, the rule requiring citizens to pay taxes on April 15th, and another rule, a rule prohibiting drug use, and another rule, a rule prohibiting murder. All these rules, they're all part of the same system, the US legal system. That's a fact that needs explaining. And the rule of recognition is part of Hart's way of explaining that fact. We'll get to all of that in a minute. Let's just start with something that Hart says. This is where he introduces a sort of pattern of thought that is very common in the philosophy of law, and it sometimes gets called a regress of legal validity. Let's just see what he says, and then we'll understand why it's called this, what this name means, and why this label is applied to it. But anyway, here's what Hart says. Is this purported bylaw of the Oxfordshire City Council valid? Okay, so we have a question. There's some bylaw. We don't even know what this rule is. It doesn't matter. It's just an example of a rule within the legal system, a bylaw of the City Council of Oxfordshire. That's the county where Oxford, the city of Oxford is. Oh, I should explain what valid means. Valid. Legal philosophers just use the word valid to mean a part of the legal system, a legitimate part of the legal system. A law is valid law if it's really law, if it really has the status of law. Whereas if you just in your garage write up some new law and then post it on the front of your house, that's not valid law. It's not really law. Okay, so the question is this purported bylaw of the Oxfordshire County Council valid? Is it law? Yes, because it was made in exercise of the powers conferred and in accordance with the procedure specified by a statutory order made by the Minister of Health. This law gets to be law because it fits with the regulations imposed by a statutory order made by the Minister of Health. One law, as it were, comes from some other law, right? This bylaw comes from a statutory order. Okay, that's what we've got so far. At this first stage, Hart says, the statutory order provides the criteria in terms of which the validity of the bylaw is assessed. We can tell that this bylaw is valid law because we check the content of the statutory order. That's what this means. This gives us the criteria for telling whether this is law. Then he says, we may query the validity of the statutory order and assess its validity in terms of, and then he's going to say something else. So now we're talking about this statutory order. What makes it valid? Where does it come from? What makes it law? And the answer is in terms of the statute empowering the minister to make such orders. There's some other law. So first we've got the bylaw of the Oxfordshire County Council. Well, that's valid because it meets some criteria set out by some order given by the Minister of Health. And what makes the orders given by the Minister of Health valid? What gives them their legal status? Well, there's some rule, there's some statute that says that the minister gets to give orders, gets to issue legitimate, valid orders. Then he says, finally, when the validity of the statute, now we're talking about this one up here, finally, when the validity of the statute, lost my place again, this is a long quote, has been queried and assessed by reference to the rule that what the Queen in Parliament enacts is law, we are brought to a stop in inquiries concerning validity. There's one more step here. This statute that gives the power to issue orders, valid orders to the minister, this statute comes from what he calls a rule that what the Queen in Parliament enacts is law. Once we reach this rule gives legal validity to this, which gives legal validity to this, which gives legal validity to this, right? But then Hart says, here, once we've reached this point, we've come to a stop of inquiries concerning validity. That is, we're done. We can no longer keep asking what makes the law or the rule legally valid. We can't ask of this, Hart says, at least not in the same way. We can't ask of this rule that gives the Queen in Parliament the power to enact law. We can't ask of it what makes it legally valid. For, he says, we have reached a rule which provides criteria for the assessment of the validity of other rules, but there is no rule providing criteria for the assessment of its own legal validity. This rule sets out the criteria, it sets out the conditions that have to be met for other rules to be valid, but there's no further rule that makes this rule a legitimate, valid part of the legal system. This is the bedrock rule. This is the rule where the regress stops, right? A regress is, it's anything where you go back, you regress, right? And so we go back and back and back to the more and more fundamental laws within the system, right? And then we reach an end to this regress. Hart ends the regress with a particular kind of rule, and that's a rule of recognition. The rule that stops the regress is the rule of recognition. And indeed, there's not just one regress. There's going to be hundreds of them, thousands of them, right? This one, it's for a bylaw of the Oxfordshire City Council. But then there's some other law, call it law number 8, right? And it is only valid. It's a legitimate law of the system because of, statute 7b, right? And statute 7b gets its power because, it's mentioned by this other statute, right? And then they all go ultimately back to the rule that the Queen in Parliament can enact law. So there's one rule all the way at the top, just one. And the fact that all of these different laws down here trace their legal validity back up to this one foundational rule, the rule of recognition, that fact explains why one law over here and another law over here are all, broadly speaking, laws of the same legal system. So we've got this fundamental foundational rule, the rule of recognition. It's the rule that sets out the criteria of legal validity for all the other rules in the system, right? It's the foundation of the entire legal system. It's the bedrock, whatever you want to call it. Where does it come from, right? If this bylaw comes from the statutory order, and this statutory order comes from this statute, and this statute comes from this rule, where does this rule come from? Where does it get its legal validity? Or if it doesn't, strictly speaking, have legal validity, where does it get its existence? Where does it get its status as a rule as opposed to just being nothing at all? Another way to put this question is just, why is it that the Queen in Parliament can enact law? The answer is this. The rule of recognition, according to Hart, is a social rule. That means that it comes directly from the people. Say that some children make up a game, right? They make up a game where, you can't step on the floor because the floor is lava, right? The floor is lava. You can step on chairs and you can jump from one chair to another chair. You can step on tables. You can take the cushions off the couch and throw them on the floor and step on those. But if you step on the ground, well, then the ground is lava. You lose that leg or something like that. They make up a game. This game consists of all sorts of rules, like the rule that says if you step on the ground with one leg, then you have to hop on the other leg for the rest of the game. And if you step on the ground with that other leg also, well, then you lose, you're out, or whatever. So they've got a game, and it's got all these rules. Where do these rules come from? Well, the rules are real. They exist. They're a part of reality. It's true that there's a rule that says that if you step on the ground with that leg, then you have to hop on your other leg, right? So that's true. So where do these rules come from? They come from the children themselves. The children create these rules, just sort of the same way that a carpenter creates a table or a building, right? We make stuff. Well, the kids, they make the rules. They create them. And the way that they create them, according to Hart, is primarily and fundamentally with their minds, with a certain attitude, with a certain mental state, which Hart calls the internal point of view. We don't need to get too into the details here, and it's actually controversial in the sort of jurisprudential literature what exactly this attitude is. But as a basic start, let's go with this. When the children see themselves or one of their playmates step on the ground and then, hop on their other foot for the rest of the game, the children think to themselves, yes, that's the right way to do it. That's the way you have to do it. That's the way you must do it. They make this kind of evaluative judgment of that pattern of behavior. They evaluate it as correct or appropriate or required, right? They evaluate those instances of behavior based on whether those instances fit with a certain pattern that they're holding in their mind. Here's another example of the same type of attitude. There's a rule of fashion that applies to men, and I suppose actually it also applies to women in certain circumstances. And the rule is something like, you have to wear a brown belt with brown shoes. If you're wearing brown shoes, you can't wear a black belt. You have to wear a brown belt. That's a rule of fashion, so I was told at some point in my life, right? Well, what makes it the case that there's a rule like that? Or what makes it the case that there's a rule, prohibiting wearing white after Labor Day or whatever, if there really even is such a rule? Well, it's just that enough people buy into those rules. They have a certain attitude. When they see someone wearing a black belt with brown shoes, they think, that's not correct. That's not the way to wear belts, right? You have to wear a brown belt with those shoes, right? And when they see someone who's wearing a brown belt with brown shoes, when they think about it, they think that that's correct, right? They evaluate that instance of behavior based on whether it fits with some pattern. When enough people, according to Hart, when enough people take this attitude towards a certain pattern, like the pattern of wearing brown belts with brown shoes, or the pattern of hopping on your other foot when you step on the ground with the first foot, right? When enough people use these patterns in these ways as standards of evaluation, well, that transforms that pattern of behavior into a rule. That's how we create social rules. Social rules exist because we think they exist in the certain particular sense. We create social rules, and the rule of recognition is a social rule. There's some group of people, we'll get to what that group is in a bit, there's some group of people who have a certain attitude towards this rule or towards a pattern of behavior or something like that. And it's in virtue of that that this rule exists and is the rule that it is. This law comes from this statute, which comes from this statute, which comes from this rule. But this rule, the rule of recognition, is a social rule. So it comes directly from the people. The people have the power. They're the ones that ultimately make the legal system, and they do it by making the rule of recognition. And that's what makes a legal system exist. Here's something else that Hart says about the rule of recognition. This is a shorter quote. For the most part, the rule of recognition is not stated, but its existence is shown in the way in which particular rules are identified, either by courts or other officials or private persons or their advisors. So what's going on here? Think about the example, Hart mentions this again in this chapter, the example back from chapter 4, I think it was, of a simple legal society with Rex, the king. The king is Rex the First. Okay, Rex is king. Rex makes the rules, right? And so there's all sorts of rules in this society. There's rules that say, you have to pay taxes on April 15th, right? Or thereabouts. That's a rule of this society. And there's another rule that says, don't murder anyone, and if you do, you'll be punished in such and such a way, right? And there's going to be even rules, let's say, that, empower judges, stuff like that, right? Let's say there's some uncertainty. There's a dispute about what the rule exactly is. Someone comes to collect taxes, and someone says, oh, taxes aren't due today. Today is April 15th. And the other person says, no, the taxes are due on April 15th, not some later date. Well, how do they resolve this uncertainty? Well, in this simple society, when they want to know what a rule is, they just think, well, what did Rex say? Because in this simple legal system, the laws are all made by the king, by Rex, right? And maybe there's some pattern or restriction on how Rex can make laws. Like when he's just sitting around in his bathtub, it's not like everything he says in there becomes law. No. Maybe the rule in their society is that Rex, he gets to make the laws, but he has to stand on the big rock in the middle of the village, and he has to hold his stick, the staff or whatever. And when he's standing on the rock holding the staff, whatever he says then, that counts as law. So there's a dispute about what the law is, and then someone says they resolve this dispute by pointing to the fact that Rex said that taxes are due on April 15th when he was standing on the rock, right? Someone says, oh no, they're due today. Don't you remember? Rex said so 6 months ago when he was standing on the rock holding the staff. And the other person says, oh, you're right. Now I remember he did say that. And so you're right, it is law. Okay, in this society, there's a rule of recognition. There's a rule recognizing these other laws, right? It's the rule of recognition, and it says something like, if Rex says it on the rock, then it's law, right? That's the rule of recognition for this simple legal system. Notice something. This rule of recognition isn't written down anywhere, right? Maybe they write down these laws, right? Maybe in this society, instead of Rex just saying what the rules are on the rock, he stands up on the rock and he writes the rules out on a piece of paper. Then he reads them out to everybody or whatever, and he posts them up on the tree or something like that. So all of these rules are written down on pieces of paper on the tree. but this rule isn't. Rex never got up on the rock and wrote down and said, whatever I say on the rock and write on these pieces of paper and post on the tree, those are law. So all of these are posted on the tree. This one isn't. This one is still a part of the legal system. It's just that you can't find it written down somewhere. Instead, if you want to figure out what the rule of recognition, you have to look at the way in which particular people act, right? The way in which rules are identified by groups of people, right? When they're trying to figure out what the laws are. Oh, they look at the tree. They look at what's posted on the tree by Rex. So the fact that they do this activity of looking at the documents that Rex posted on the tree, that shows that there must be some other rule, even though that rule itself is not written down, and it's the rule that decides which other rules count as law. The point of all this is that in simple legal systems, the rule of recognition is not written down. Maybe, debatably, in other legal systems, and this is a point of controversy which we will return to later in the course, right? The rule of recognition is written down. Maybe it's just the Constitution, right? If there's a written Constitution, maybe that just is the rule of recognition, the ultimate law at the foundation of all the other laws. Maybe. We'll get into the details of that later in the course. But if you want to think of the Constitution as the rule of recognition for now, that's fine. That's fine with me, at least. Although there might be some problems to that claim. It might turn out that the rule of recognition has to be some silent, unspoken law that just points at the Constitution and says something like, whatever the Constitution says goes. Maybe that's really the rule of recognition. It's one step more fundamental than the Constitution itself. Maybe. The point is just this: rules of recognition, these social rules that are created by people in their minds, right? It's created by the people in this society, right? Rules of recognition don't need to be written down. They don't need to be stated anywhere. They can just be shown or demonstrated by the ways in which particular rules, that is, these specific rules here, particular rules are identified either by courts or other officials, right? So by judges or police officers, say, or council people, right? Or private persons, ordinary people, or their advisors. I think that means the lawyers of the private persons, right? If a bunch of these people, enough of the right people here, if they defer to the documents that Rex posted on the tree, right, in order to determine what the law is, if they defer in that way, then that just shows that there's a rule like this operating in the background, a rule that they accept by taking the internal point of view and that thereby exists and functions as the foundation of the legal system. There's one more little snippet from Chapter 6, The Foundations of a Legal System, that I want to talk about. This is the moment. This is the place in the chapter. It's towards the end. We read this, but we read this part as well. This is the place in the chapter where Hart just states, as simply and boldly and directly as possible in a single sentence, what his theory of law is. That is, he presents the conditions that he thinks are necessary and sufficient for the existence of a legal system. Here's what he says. There are therefore two minimum conditions necessary and sufficient. Oh, okay. If you don't already know what these terms mean, necessary and sufficient, or aren't familiar with them from philosophy classes that you've taken in the past, this just means that these conditions are required, they must be the case, and they're enough. Necessary and sufficient. Needed and enough, right? So these conditions are all you need, they're sufficient, but you do need them, they're necessary, for the existence of a legal system. Okay, so here are the two ingredients. You've got to have both of these ingredients if you want to have a legal system. And if you have both of these ingredients, then you've got a legal system, according to Hart. Here we go, the two necessary and sufficient conditions. On the one hand, those rules of behavior which are valid according to the system's ultimate criteria of validity must be generally obeyed. That's the first condition, right? So citizens, ordinary people, enough of them. How many? Enough, right? The citizens must obey, the primary rules. Right? So those rules, right down here at the lower level, that meet the criteria of validity specified at the upper level, enough of those rules need to be obeyed enough of the time by enough of the people. The first thing you're going to notice about this is that, broadly speaking, something here is right. If you've got some rules that are generally disregarded, then you can still have a legal system. But if people are disregarding most of the rules or almost all of the rules, right? If everyone's running around stabbing one another, taking one another's property, even though all of these things are strictly prohibited, but everyone's doing it, then you might say that this place where this is going on is lawless. That's exactly what you'd say, and that's what you should say, and it is lawless. You'd be right to say it. You need to have enough obedience. How much exactly? Well, Hart is rather vague about that, but I think he's right to be vague about it, because the existence of a legal system is a vague matter. Some legal systems are borderline, whether there really even is a legal system in this country. There are rules, they're followed some of the time. Is it enough to make it a legal system? Well, it's close, and so, right, the degree to which the rules are consistently obeyed, well, that corresponds exactly to the degree to which the legal system counts as a real legal system. He's vague about it, but that's the right thing to do. One should be vague because the phenomenon itself is vague. Okay, that's the first conditions. Enough of the people have to follow enough of the rules enough of the time. That's condition one. Notice, by the way, this is a behavioral condition, right? This is satisfied, this condition, if there's just some facts about the behavior of the people, right? And behavior just means the outwardly observable movements of someone's body and the sounds that come out of their mouth and that sort of thing, right? What can be observed by other people. So this condition is behavioral. And then he specifies the second necessary and, jointly with number one, sufficient condition for the existence of a legal system. He says, on the other hand, its rules of recognition, that is, the rules of recognition, it's funny that this is plural. Anyway, it is plural in the text. The rules of recognition of the system, specifying the criteria of legal validity, that's what rules of recognition do. They say what other rules have to do to be legally valid. Those rules of recognition and its rules of change and adjudication, the rules of change and adjudication which we talked about from chapter 5, of this system, right? They must be effectively accepted as common public standards of official behavior by its officials. The other condition is that the officials of the system have to do something. They must accept the rule of recognition and some other rules, right, as standards for their own behavior and the behavior of other officials. Okay, so it sounds like in this case, Hart is thinking of the rule of recognition and these other secondary rules as duty-imposing rules that apply to officials. Anyway, that's a side note. Don't worry if that sort of went over your head. That's an extra detail. But anyway, the officials must accept these rules. Acceptance, by the way, is just another name that Hart uses for the internal point of view. They have to think of these rules in a certain way. So this condition, this second condition for the existence of a legal system, this is a psychological condition. This is a fact or a putative fact about how the officials think. They have to think in a certain way. They have to have a certain mental state, right? Or be in a certain mental state. If enough of the people follow enough of the rules, Hart says, and if the officials of the system, if they internalize those rules and use them to judge instances of their own behavior and the behavior of other officials, well, then a legal system exists.